fundamental and substantive rule of law designed for public policy and private peace, which should be cordially regarded and enforced by the courts. Those are the late Justice Rehnquist's words from the 1981 Supreme Court case Federated Stores versus Moti, and they properly encapsulate why res judicata is so important in this case. It is here to avoid needlessly duplicative litigation, and that's what we've got here. We were just talking about the state case where the appellant and 6 other former servers of Thai Gourmet filed suit under a variety of theories. Lack of overtime, wage theft, but as we also heard, wrongful termination. And that wrongful termination claim was later dropped in the amended petition. When the parties settled their case in the state court matter, appellant specifically asked for and got that carve-out in the settlement agreement saying that she reserved the right to bring an FLSA retaliation claim later. But what was just as important is the settlement agreement was completely silent about the defendants waiving any defenses they had regarding that claim. And what was just as important is when you look at the order of dismissal, there was no carve-out relating to the FLSA retaliation claim. This is the essence of res judicata, and Texas law rejects this kind of claim-splitting approach.
What's your best case for that proposition?
Well, 2, Your Honor, but I would primarily rely on the Citizens Insurance versus Dockage case. It is 217 Southwest 3rd 430 from 2007. The Texas Supreme Court addressed the issue in the class action setting about whether claims which had been raised and then dropped later on could then be revived in another suit, and the court specifically said they could not. In fact,
I guess the way I was looking at that, though, was yes, the could have brought test exists, but antecedent to that is it the same subject matter? And I just still have a hard time thinking wage theft is pragmatically the same subject matter in terms of trial units as a wrongful termination case.
And that would be an important question to address if it hadn't already been conceded by the appellant. In her original petition, she brought an unlawful termination claim. She pled all the facts relating to her unlawful termination.
Right, she could have, but it doesn't make the transactions the same. To me, it seems chronologically, in origin, in motive. This isn't a sequence of connected, different. She isn't relitigating a wage theft case. She's got a totally separate issue unrelated to the other 6 servers. She gets fired. That's wrongful. It makes sense, even frankly, for your client. I don't want to litigate that in this. And we write the settlement. It's not going to be vexatious. She gets to bring it. It's totally separate. It has to do with her and why she was fired.
Well, that's correct, Your Honor, but they're inextricably linked because the evidence used by the appellant to prove her wage and theft claim was then also alleged by her to be the cause of the retaliation.
The nucleus of fact, it's not an elements test, right? Between the 2 claims?
Well, Your Honor, the federal courts used the federal test talking about the same nucleus of facts. Judge Duncan, last July, you gave us the test from 3 Star Properties versus SED Holdings. And the 3 elements were related on when Texas law applies when a court determines the preclusive effect of a Texas judgment. So the test is a little different from the federal test, which I think Judge Hughes used in the district court case, but the result is the same either way. The 3 elements in the SED Holdings case are, number 1, the prior final judgment is on the merits by the court of competent jurisdiction. That's not an issue here. We've got a settlement and a final judgment. Number 2, the parties are identical. Again, not an issue. And so number 3 is the second action is based on the same claims or claims that could have been raised in the first action, and that's where we are. Because when you look at the original petition, she brought a wrongful termination claim. She alleged all the facts related to the wrongful termination claim. And you just heard her say yes, but that was under a state theory. But then in the amended petition, and you'll see that under ROA 219, she then dropped the wrongful termination claim, but added FLSA claims. So at the moment she did that, she knew she had the opportunity to bring an FLSA retaliation claim. She split it off for whatever reason. It's a tactical reason. It's up to her. But at the moment she filed the amended petition, she dropped her retaliation claim and just kept and added in FLSA claims. At that moment, she achieved element 3. She had the same claims, and she could have continued forward with those claims. She could have added the FLSA claims. There's something like 9 months between the amended petition and the settlement. And it's unclear why she didn't raise the FLSA retaliation claim in state court. It was a tactical choice. She was entitled to do it. She put a carve-out in the settlement agreement, but that doesn't allow her to argue that res judicata does not apply in this case. The three elements are met. What we were talking about from the appellant's side is you heard her saying that the subject matter of the two claims are different, but the evidence being used would be the same. And you're right, Judge Higginson, we're not talking about a strict timeline, but what we're talking about is the sources of evidence used. Her main argument is, well, I was in these meetings, and at the time I was in these meetings, various employees raised these issues. The evidence, as you go into the record on appeal, talks about what kind of issues were raised, what kind of questions the appellant asked. She asked only 2 questions in the meeting. She said, how do you deduct tips per person, and do we get any deduction from the tip base of total sales? The point is, this was not an FLSA protected activity, because at this point in time, Department of Labor regulations allowed tip pooling, and they allowed credit card charges to be deducted from tips. That understandably caused some confusion. But those questions by themselves are not protected activities. Those are honest questions asking how much is being deducted, not why are these deductions being made. These deductions can't be made. And she asked those questions. But most importantly, you can't establish an FLSA protected activity because the Starnes versus Wallace case from this court in 2017 sets up the issue. Did the defendant retaliate because the plaintiff engaged in a protected activity? So you have to establish the causation there, and there's no causation here. Because as we have seen from testimony of the defendant, the owner from Sworn, and the restaurant manager at ROA 466, both of them said they did not understand why the appellant stole the sales reports. And then the appellant herself testified at ROA 466. She did not tell the owner of the restaurant that she stole the sales reports before she was fired. You can't impute that knowledge that simply isn't there. And the only argument the appellant have in that regard is this tortured chain, saying, well, we think that another server may have told the manager of the restaurant, and that's enough. But the manager of the restaurant is not the person who fired the appellant.
These arguments might prevail in the eventual FLSA termination case, right? But these aren't really going to the res judicata issue.
Correct, Your Honor. And we don't even need to go into the merits any further, frankly. The res judicata issue is dispositive of the case. And for judicial economy, we can stop right there. We've talked about in our briefing the 3 reasons why we succeed on the merits. The protected activity, which we just got into, the lack of causation, which we also discussed a little bit, and thirdly, the reason for termination was legitimate. But those are briefed, those are before the court. And I would also ask the court, if you're going to reach the merits, that I ask that you actually review the affidavits and the evidence that was relied on by the appellant in her summary judgment motion. We made objections to hearsay to a number of those affidavits. The objections are preserved at ROA 359, 385 through 395, and 461 through 462. They were not ruled on by the district court because they didn't need to be ruled on. The court ruled entirely on res judicata. This court can simply affirm the trial court's decision and leave it there. It really goes back to what the Texas Supreme Court said in the Citizens Insurance case. It said it is time to bring an end to litigation, time to prevent vexatious litigants, a time to maintain the stability of court decisions, a time to promote judicial economy, and a time to prevent double recovery. And that's all we're asking this court to do. If there are no further questions from the court, I will yield the rest of my time. All we simply ask the court to do in this matter is to affirm the trial court.
The company would defend on the basis that she took documents away from the company, right? And that's why she was fired?
That is correct, Your Honor. And we've cited to a number of evidence of why those sales reports were so important.
Right. Okay. Thank you.
Thank you.
Okay, Mr. Bunker, rebuttal.
Case. It's basically they're saying there's no retaliation because one, she was not engaged.
Address council citations to Citizens Insurance Company versus DACOC from Supreme Court of Texas. Seem to be a key
Yes, sir.
case in the race judicata argument.
Yes, Your Honor. As Judge Higginson pointed out a few minutes ago, and what seems to get lost in the argument from the defendants in this case sometimes is that the first step is that there has to be an identity of claims, identity of facts. And that's what we don't have here. The claims they're contained within the same statute, but they're two totally different claims. They have two totally different motivations. The wage claims were over a period of years. The termination claim was 1 day. And as I already discussed previously, all of the evidence required to prove the wage claims is distinct and different. The relief is entirely different from between the wage claims and the retaliation claims. Now, as far as public policy goes, one of the main thrusts of the public policy of res judicata is to prevent a double recovery, which is not something that's going to happen in this case because the damages are entirely different. And again, just because Ms. Pimpinett could have brought the claim in the state court doesn't mean she was required to bring it.
You didn't even cite Citizens Insurance in your briefing.
That was I didn't, they did.
Okay, I'm just pointing it out.
The other side said.
I know that.
I cited DeBar, which is
Right, I know you cited Barr.
I mean, in Barr, the Supreme Court wrapped up years of confusion in Texas about res judicata and adopted the transactional approach.
Well, what it mainly says is it's a transactional approach.
Right.
But, you know, what would you do with a case where plaintiff sues the other side for breach of contract and breach of fiduciary duty, and they settle contract, and he reserves fiduciary duty, and then he sues him again for fiduciary duty?
Because if the fiduciary duty claim arises out of the same, out of the contract or out of the duties that arise under the contract, then it would be barred.
But it might not, right?
I'm having a hard time thinking of a circumstance where it wouldn't, because that's what we're talking. That's what the case
I don't mean to go down a rabbit trail.
No. But the case that the defendant relied on, Robinson v. Garcia, an Texas appellate court case, involved malpractice by an attorney, or alleged malpractice by an attorney, and the malpractice had to do with the settlement of the claims, and the lawyer advised the client to characterize the proceeds a certain way for the IRS, and allegedly took more than the contingency that had been contracted for between the parties. Years of different spin-off litigation, the claims settled, and a similar carve-out, and I think this is why the defense used it at the district court, similar carve-out for the negligence claims for one of the claims, but in that case the lawyer specifically gave notice to the client and the client's attorney that he intended to rely on the defense of res judicata if they proceeded with the second lawsuit. And so the court in that case went to more of an equitable approach and said that there's no inequity to preclude a second claim based on res judicata under those circumstances. And if I may very quickly address something that Mr. Ravel had begun to talk about, is that the argument that the owner of the restaurant did not know anything about the complaints being made is false. My client's declaration, the record, pages 451 to 452, she was in that meeting, and she said, if you don't like how things are going here, then you can just go somewhere else.
Overtime violation, you violated.
Thank you very much.
Thank you.
The sales records are trade secrets. So that's the response from the plaintiff. And I want to talk to you about summary judgment itself, okay? When you have an issue of facts, in summary judgment, when you have an issue of fact, it has to go to a jury because the judge cannot make a decision on the merits based on who he believes. They can't make credibility decision. So if you have a question whether or not someone was motivated by legit concern about theft of trade secret, or they're concerned about someone tattling on them, reporting them, suing them for tip and overtime violation, all of that should be presented before a jury, not a judge. So going back to this briefing, that's what the plaintiff argued, that, hey, the reason given by the employer was pretext, meaning it's just made up reason. The real reason is retaliation, and that's why we have a good case. They also addressed the Restjudicata argument, and they make a good point that these facts arise from different facts, meaning the facts to prove up theft of tips and overtime is payroll records, time records. The facts for proving whether or not someone was fired for reporting tip violation, overtime violation, that's totally different because now we're talking about, well, number one is the sales record, daily sales record for 2 weeks. Is that trade secret? Number two, is that really stealing? And number three, is that protected to gather evidence needed to prove your lawsuit? So I thought the response brief was good. And here's the opinion issued by Judge Hughes. And this is kind of short, but it's not unusual. Judge Hughes doesn't give like really long briefs, memorandums. But he basically says, yeah, the settlement may have allowed her to file a retaliation lawsuit, but yeah, I'm going to dismiss it because it's the same facts. Now, the judge says this is his own standard. It's just his opinion. It's not the law. Is that the facts in both cases does not have to be identical. They just have to arise from the same nucleus of operative fact. What this means is that the essential facts of the case, are they the same for each case? And so the judge is basically substituting his opinion. He's saying, well, the facts to prove theft of wages and overtime is probably the same as the facts needed to prove that someone was terminated for complaining about it. I beg to differ, but that's what the judge said, and he signed it and dismissed the case on May 4th. So there was an appeal filed because of this, and so let's talk about the appeal. There was an appeal to the Fifth Circuit Court of Appeal. You're going to see some important things here. I think the Fifth Circuit Court of Appeal looked at it, gave the parties some basically some calendaring options, and then the parties briefed it up. So let's take a look at the appellate brief after Judge Hughes' opinion. So this is the brief filed by the appellees. This is the party that's resisting the appeal. They were represented by Bruce Johnson. I thought he did a pretty good job. And he wrote a pretty good brief, but basically all he's saying is that she can't prove that she was retaliated. All right, well, that's a factual issue. The jury should decide, not a judge. Argument number two is Restjudicata prevents her from bringing her claim of retaliation after she settled her overtime and tip pool violation case. Okay, that's basically the two opinion, or the two factors on appeal. Now, the response filed by Joe Bunker is pretty good. So here's his reply brief because he filed an appellate brief in the first place. But basically, he's arguing that what Texas law actually says about res judicata, they're wrong on the law. They're arguing the law, or they don't realize what the law says, and so that's what happened there. So I think that when you look at appellate briefs, you have to take it into consideration that it's not. These are just opinion, but you have to look. You have to rely on case law. You just can't give your own opinion. You put your spin on it, but at the end of the day, you still have to follow Texas law on what res judicata is. So the interesting thing is that both parties waive oral arguments. So when a case is before the Court of Appeal, you have an option of traveling down to New Orleans, appearing before a panel before the Fifth Circuit, and making your argument. And then you can also waive it. Say, I don't need to, because oral argument will not help that much. But the really funny thing is, the Fifth Circuit really wanted oral argument. So they invited the parties down, and on January 4th, 2022, there was oral argument. You can visit the Fifth Circuit's website and look at an oral argument. Click it, and there are MP3s that you can download and listen to. And the MP3 for this oral argument is like 30 minutes long, but I would say the first 15 to 20 minutes is really helpful because even for a non-lawyer, just listen to it to hear justice in action. And you can see, you can visualize, when the judges are asking questions, they're kind of leading the conversation, and they're leading the conversation towards the fact that they're not buying Thai Gourmet's argument about res judicata, and you can tell that they were not buying it because they were asking, they did their own research, and they were asking the lawyers questions about their decisions, what these cases say. Oh, that's a tongue twister. So this is the decision that was issued on March 23rd, 2022 by the Fifth Circuit. And it kind of summarized that she had removed data reports from the restaurant, and she was fired. And she alone was fired, so she sued the defendant. That's what the Fifth Circuit decision kind of gives a background on. And it explains everything about her taking the restaurant's daily report to prove her case. And the oral argument is really interesting and enlightening because it talks about how it kind of overlaps, but it really is not the same facts because the Fifth Circuit felt that the facts necessary to prove minimum wage violation and overtime violation, it's got nothing to do whether or not she took daily reports from the restaurant to prove her case and whether or not she should have been fired for it. The Fifth Circuit does a good explanation what res judicata is, and then, but this is key here, I think, because of oral argument. I think that the three-judge panel talked about how Texas court takes a transactional approach on whether or not the prior lawsuit was the same matter as the second lawsuit. So they say that it has to arise out of the same subject matter, okay, that were litigated. So the subject matter below district court, the first lawsuit was whether or not Thai Gourmet had stolen waiters' tips and cheated them with overtime. The subject matter for the federal case, the second lawsuit, that has everything to do with whether or not she removed daily reports, and was she fired because of that, or was she fired for complaining about overtime? So that's what we're talking about. So they agreed with Jenny's lawyer, and she says that she felt that her federal retaliation claim didn't arise out of the same subject matter as the underlying claim for underpayment. And the Fifth Circuit agreed. They say that the key facts concerning whether or not she worked overtime and receiving tips, I mean, it doesn't overlap with her termination. So do hinge on the point that while her federal lawsuit do mention that Thai Gourmet had a scheme to steal servers' tips, that was really for context. It's not the federal lawsuit was not based on those facts. It's just giving context on why she bothered removing those records. And so the decision is that the district court shall reverse the case and remand it for the proceeding. So that's basically a win. And I noticed that Joe Bunker, the plaintiff's lawyer, filed a status report on May 3rd, 2022, and basically saying it's going to take 2 days to try the case, and the defendants plan to file another motion for summary judgment on July 18th, 2022. So maybe Judge Hughes is setting this case up for another round where he can throw the case out a second time if the defendant want to file a second motion. So here's my opinion on this. I don't think that Thai Gourmet shut down because of the lawsuits. I can tell you that they spent a boatload of money on the defense of the case. Why do I say that? Well, if you just simply look at the docket for the federal case, look at all the filing they did. And then you take a look at the docket for the Court of Appeal, they probably spent over $100,000 on attorney's fees, easy. And they should have just settled it because she was suing them for her lost wages. This one person. I don't know how much a waiter makes, but if you're paying someone less than $7.25 an hour, and they're working 50, 60 hours a week, her lost wages would not be $100,000 in a year. So if they lose this lawsuit that's back in Judge Hughes' court, maybe $50,000, $60,000 in lost wages. But in the process, just to fight this case and defend it and go on appeal, they spent over $100,000. So I think her defense lawyers gave her bad advice. Gave the restaurant bad advice, and they basically padded her pocket for a bunch of money. But maybe, I'm just looking from the outside, maybe you have someone who is an owner of a restaurant that wanted to make a point and wanted to fight it. And so the lawyer did their job, and they fought it, and they spent a lot of time and money trying to get the case thrown out, and they made good arguments that had some valid claims. You can make the argument either way, but at the end of the day, the restaurant shouldn't close over one lawsuit about wrongful termination / retaliation for one person, because the recovery is just attorney's fees and then one person's lost wages. I'm sure she has found work somewhere else at another restaurant, so it's not like you're sitting there at home for over a year without any type of wages. So, but here's an observation I have. There's a high likelihood that Thai Gourmet will win this lawsuit, and here's why. I've been before the same judge representing a waiter against a restaurant, and I know what it's like to lose before this judge, to go up on the Court of Appeal, win the appellate decision, get this judge reversed, and then go to trial before him. I think what will happen is that Jenny will face two hurdles. One is she probably will face another summary judgment motion filed before July of this year. Number two is once she gets to trial, she'll have a very hostile judge that wants to throw out her lawsuit and will be looking for reasons to kind of bend the procedure and the proceeding and give her a hard time, her and her lawyer a hard time, because that's my personal experience. I think that you're going to have a hostile judge at trial, so it's likely that Thai Gourmet has two chances of winning, and so they're not going to have to pay a bunch of money. If they win this at trial, the plaintiff's lawyer gets nothing, and Jenny gets nothing. So all they're out of pocket is the money that they paid their lawyer. So we'll just have to wait and see. If you have any questions, just let me know. Comment below.